Officer Dave, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Good morning, Counsel.
Morning, Your Honor. How are you?
I'm not bad. How about yourself?
Doing well.
Ms. Schwartz?
Good morning.
Are we ready to begin?
Yep.
Let's call case number 21-164-260. Aspen Cares Pharmacy versus State Farm. Your respective appearances.
Rachel Schwartz on behalf of the plaintiff, 54947.
Ryan Bates on behalf of defendant, State Farm, P77460.
All right. What is the status of the interlocutory appeal over there in Wayne Circuit?
Your Honor, it was heard, and I don't know if an order was entered yet, but the judge overturned the decision.
Okay. So where's my opinion?
Ryan, do you know, was there an order entered?
There was an order entered. I don't think she did a written opinion. I think the order entered. Let me check real quick. I thought the order she entered just. Yeah, there's no written opinion with this order. It just says reversed for the reasons stated on the record. I don't know if she's planning on issuing a written decision or not.
Okay.
I don't think so. I think she asked for an order.
For my enlightenment, what were the reasons stated on the record?
She said that the 1 year back applies the same way that we used to. I mean, from the date that the expenses incurred, and then it's submitted to the insurance company. It's told during that time, and the 1 year back doesn't start until the date that it's been denied, I think is what she said.
Okay. So then we should proceed then. Somebody needs to give me a copy of that order, whatever it was. The 2.302A disclosures have been made here, so you guys need to get moving on your file. So let me just give you another date and get you on your way.
Well, Judge, may I?
Sir.
The disclosures we received from plaintiff is just a billing ledger. I was hoping to get the actual prescriptions, what the dispensed items or medications were. If the plaintiff has it, the records of the referring prescribing physician. So I would request either supplemented initial disclosures or the opportunity to request to produce.
Yeah, I'm happy to get you whatever you need. I mean, the ledger though indicates what was prescribed though, right?
Maybe by code like J8499, but that's every code. I don't know.
Okay.
And there are various prices, so I don't think that's the item.
It just, there's no like actual medical records with the pharmacy bills, but let me see what I can do. I'm happy to produce whatever you need.
All right. Well, let me get you guys another date and get you on your way. Does June 15th work for both of you at 10 o'clock?
June 15th. Let me just look.
It works for me, Your Honor.
At 10 o'clock?
Yes.
No, I have a deposition.
All right. How about June 14th?
No, I can't do that, Dan. I have to be out for a doctor's
June
appointment.
16th.
Sure.
Mr.
At
Bates?
10?
Yes.
Yeah, I can do 10 on the 16th.
All right. June 16th at 10 o'clock it is. And somebody provide me that order or opinion from the circuit court.
Okay,
Yes,
Ryan, do you have that? I don't think I've seen it come through.
Yeah, we can mail it to the district court.
Okay. Okay, thank you.
All right. Thank you both for coming in. Let's be safe.
Thank you. You too, Judge.
We're off the record.
Take care.
You too. for Mr. Childress and Sisler 044. Mr. Sisler, good morning.
Good morning, Your Honor.
I need for the defendant to unmute and turn on her video. Hello? Unmute, please.
Hi.
Yeah, let's get started.
Okay.
This is case number 18150-044. Gateway Financial versus Raven Childress. Date and time for objection and garnishment. Your appearances.
Good morning, Your Honor. May it please the court, Scott Schisler, P48832, on behalf of the plaintiff.
What is your name, ma'am?
My name is Raven Childress.
You are the moving party, ma'am. What is the basis of your objection and garnishment?
Oh, my objection is that I'm not able to like afford food and rent as far as like the garnishment, but like I can still pay, but the amount is like just too much. Like I'm not able to afford my bills and I'm behind on rent because of it.
Ma'am, do you have any other basis for your objection to garnishment other than financial hardship?
No, sir. That would be most of it.
Okay, Mr. Sisler.
Your Honor, that is not a basis of an objection for garnishment. There is a motion for installment payment that she could file that would address those particular issues, but that's not what's before the court today.
All right. Ma'am, the only matter before me today is the objection to garnishment and whether you have demonstrated some defect in the garnishment proceeding itself or some reason that it is not valid. You failed to do that. Your objection to garnishment must be denied. You, of course, have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. You have an absolute right, ma'am, should you choose to do so, to file and serve a motion for installment payments. You filed and served a motion for installment payments. 14 days or so after that it has been filed, the court will be submitted to me for review. If the court grants a motion for installment payments, it of course would prevent wages from garnishment in exchange for whatever the court ordered installment payments were. Okay?
Okay.
All right. Thank you both for coming in. We're off the
Thank you.
record. Let's be safe. Mr. Ruzen?
Yes, hi, Judge. How are you today?
Good. How are you?
Oh, just fine.
We're waiting for Ms. Holmes Knox to connect audio. Are we all set now? Everybody here?
Yes,
Okay, let's call your case. We are on the record. This is file number 201512223, AutoVest LLC versus Tanya Renee Holmes. This is the date and time for an objection to garnishment. Could I have your respective appearances?
Judge, may it please the court, my name is Attorney Richard Bruson. For the record, my bar number 35222. I am the attorney of record for the plaintiff, and today I am the respondent to defendants to an objection to a bank garnishment.
What is your name, ma'am?
Kiana Holmes.
You are the moving party. What is the basis of your objection to garnishment?
The amount when they took the car, it was like, I want to say like 2,000 left on the car. And then like with penalties and stuff, it came up to 5,000 and something, and I can't afford to pay 5,000. I can do a payment plan, but I don't have 5,000 just to pay today.
All right. You have anything else you want to tell the court?
They had been garnishing my taxes. So like, did that like go towards the balance or anything?
Any money that they have received by way of garnishment does, of course, be credited against the amount that you owe. Yes, ma'am.
Okay.
Mr. Rosen.
Judge, may it please court, for the record, first off, initially, I would say that defendant's objection to the bank garnishment should be denied because under Michigan Court Rule 3.101K, defendant initially attempted to attack the underlying judgment, which is in black and white letter law, barred, prohibited by Court Rule 3.101K. Now, on the other hand, if defendant wants to make an installment payment petition to get this judgment behind her, I can entertain that now. But I need to hear what she is able to pay per month.
Let me stop you both right here. And let me finish, first of all, see if there's anything else, ma'am, you want to tell me in relationship to your objection to garnishment.
No, not at the moment.
All right. Ma'am, the objection to garnishment must be denied. Financial hardship is not a valid reason for objection to garnishment. Objections to garnishment may only be based on defects in or the invalidity of the garnishment proceeding itself. You cannot use the objection to garnishment to say there's something wrong with the underlying judgment. So I'm going to deny the objection to garnishment. You, of course, have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. Now, if you want to enter into negotiate some sort of payment arrangement, I can put you guys in the chat room, or you have another alternative. You can file a motion for installment payments. But I should point out to you that a motion for installment payments, if the court grants it, does not protect bank accounts. It merely protects wages. It doesn't protect lottery winnings, money, credit union accounts, just wages. You understand that?
Yes.
Okay, so you want me to put you guys in the chat room, or you want to file a motion for installment payments?
We can go to the chat room.
Okay, if you resolve something, come back to me.
Okay.
Otherwise, you're free to go, and I will send out to both of you an order denying the objection for installment payment. Denying the motion for objection to garnishment. All right, let me see if I can get you guys to a chat room here. We got rooms. Okay, so that would be room 7 to 1. Assigned to room 1. Yeah, okay. Hello?
Hello, can you hear me?
Yes, what is your name, ma'am?
My name is Amber Edwards.
Why are you here today? I don't have you on my docket.
I actually was supposed to be here at 9:30, it says today.
No, ma'am. My case is set at 8:30. I was set at 10 o'clock. What is your case number, ma'am? It's in the upper right-hand corner of your document.
SP 125-88982 space 0 and the letter I.
No, that's not it. Do you have something with the court's log, the court caption on it?
It says Johnson R. joined Zoom hearing at 5/18/22 at 9:30. It says informal hearing.
Okay, you're supposed to be in a traffic ticket, madam, ma'am. This is a civil courtroom. You're in the wrong courtroom.
Okay, my apologies. Thank you.
It's all right, ma'am. Have a good day.
You too.
Mr. Rusin, were you able to resolve it?
Well, yes, Judge. Do we have Ms. Holmes back on? Did she leave the breakout room?
I don't believe so. Let's see. Bring her back here. All right, Ms. Holmes, you're both back? Okay.
Yes.
You're back then on file number 20151-223. The case is entitled AutoVest LLC versus Tiana, Renee Holmes. You folks were able to work something out?
Yes.
Yeah, thank you, Judge. May it please the court, Richard Grusin, my bar number 35222 for the record. Judge, while the case was in recess in the breakout room, the parties have agreed to stipulate to enter an installment payment order whereby the sum of $150 per month will be paid by Ms. Holmes beginning June 17th, 2022, and each 17th day of the month thereafter. Judge, if the court will issue the form from the form it may have there now, I noticed that, in completing the form, there has been no periodic garnishment issued that brought the defendant to the docket today. It was only a non-periodic garnishment. But nonetheless, I will stipulate to the $150 a month. And I explained to Ms. Holmes off the record how those monthly payments could be effectuated to be paid to me and not directly through the court, since the court doesn't have any bookkeeping apparatus for that purpose.
All right, somebody needs to send me in a stipulated order.
I see. Well, okay. How about this? How about if I do it by someday rule? That way, Ms. Holmes, just as she knows, when she gets in the mail, she can look it over. And if it's everything that we've stipulated to on the record, then she doesn't do anything and the court will sign it subsequently. I am going to be down tomorrow morning filing at the clerk's office by hand, Judge. That's why I believe that may be the best way to effectuate the order getting up to your chambers.
Ms. Knox, did you hear those terms?
Yes.
Do you agree to those terms?
Yes.
Do you understand those terms?
Yes.
Okay. What I need you to understand is that even if I enter an order for installment payments by agreement, it only protects wages. It doesn't protect bank accounts, lottery winnings, anything like that. You understand that?
Yes.
Okay. I look forward, to the order.
All right. Thank you, Judge.
Susan, you still got two more, I believe, in my court.
Yes, I do. Yes, I do indeed.
If you're back in the waiting room, Ms. Holmes, you're free to go.
Okay,
Oh.
thank you.
Okay, Mr. Rusin, I have a new person who just arrived.
Oh,
Let's see who that is. Admit. Hello?
Hello,
What is your name?
my name is Cassandra Bell.
Ma'am, you're not due here until, wait. Cindy Bell, ma'am, you have an 11 o'clock, ma'am.
Oh, see, I don't really know much about the Zoom stuff,
Yeah,
and I didn't know if I could.
You're real early. You can come back at 11, or I can put you in the waiting room. It's up to you.
Just going to put me in the waiting room, Your Honor.
Okay, I'll do that.
Thank you.
Mr. Ruse and I don't have anybody else from you, so I'll give you a couple more minutes and we'll get back to you.
Well, that's okay, Judge. I don't know much about Zoom either, so I'll leave it to you.
Oh. Hello,
Hello, Judge.
Yes,
what is your name?
Tanya Robinson.
We are on the record calling file 19169-579. Automotive Credit Corporation versus Tanya Robinson, date and time for objection to garnishment. Your appearance.
Judge, may I please the court? My name is Attorney Richard Rusin. My bar number is 35222. I'm the attorney of record for the plaintiff, and I'm the respondent to defendant's wage garnishment.
And what is your name, ma'am?
My name is Tanya Robinson.
What is the basis, ma'am, of your objection to garnishment?
Well, the garnishment was for $12,414 that was taken from my pay, which ended January 21st. It said it was completed in my ADP. Now, 2 months later, they come up with another $2,000. And I don't understand how that is when it was completed.
Now, wait a minute, I didn't understand you. Are you telling me you were garnished from your pay for $12,000?
Yes,
Ma'am, garnishments are limited to 25% of the paycheck. You telling me you had
no,
$48,000 paycheck?
no, I'm saying over the time of the garnishment.
Oh,
The total was $12,414,
all right. So your claim
which
is
was
that
garnished,
your claim
which
is
was
that
garnished.
your claim is that the amount has been paid.
Yes,
All right, Mr. Rusin.
Judge, may I please the court? I literally have over 30,000 cases in my office, all of which I have electronically calculated as to the statutory interest cost and garnishment filing fees and that I have to report to the court as an officer of the court. I can tell you as an officer of the court and also Ms. Robinson that to date, I have received $13,087.23. The last payment that I posted on the judgment as a partial satisfaction was $109.73, which I posted on May 13th of 2022 when I received that from Ms. Robinson's employer. I am still showing a remaining statutory balance on this judgment of $2,116.27. The court register of action will verify that judgment in this matter entered on November 26, 2019 in the amount of $11,994.65. Therefore, I will submit to the court that because I'm showing statutorily due under MCLA 600.6013 and Michigan Court Rule 2.625 for taxable costs, once I receive the final $2,116.27, I will file a satisfaction of judgment, file a release of the periodic continuing garnishment, and then the case will be closed at that time.
All right, Ms. Robinson, the problem that you have is that the judgment that was entered against you on November 26, 2019 was in the amount of $11,994.65. But it bore interest, ma'am, at the amount of 13% a year. So that means 1 year from the date that the judgment was entered, it was no longer $11,994.65, but it moved up to $13,553.22. And that would have been in November of 2020. So the problem that you're having is that the interest on the account is accruing at more than 1% per month. And let's say for purposes of our discussion, the amount of the judgment was $10,000, just to make my math easy. That means you'd be accruing more than $100 a month every month, simply in interest. It would not be going to paying principal. The court's going to find you have failed to state a valid objection to garnishment because you have, of course, an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. You're paying.
Okay.
Excuse me.
2 months later.
Ma'am, when did you start paying?
At my ADP, it said it stopped. It was completed January 21st. So they started up again. They found the $2,000 discrepancy 2 months later.
When did you start making payments, ma'am?
Oh. Let me see.
I can be helpful. The last payment that.
No, that's not what I want.
Yeah,
I want to know when she started to make payments.
okay. Let me go back in time. I see the first payment from the employer was back on October 8th of 2020 with a periodic garnishment payment at that time of $204.31.
All right, so that's going to be 11 months after the judgment was entered. Is that right?
I'm looking at, just bear with me, Judge. I want to get the copy of the garnishment here. So yeah, the wage garnishment was issued in December of 2019 and then served by certified mail to the employer that went out of my office January 6th of 2020. And I received back by January 10th of 2020, the certified mail of the service of the garnishment.
So that it as a practical matter, you started the garnishment in essence.
Yes.
3 months after the judgment.
That would be a true statement.
Okay. And did you end the garnishment? She said that the garnishment was terminated at some time.
May I address that, Judge?
Go ahead.
I'm going back on my screen now. In January of this year, I'll get you the time and the date here, Judge, one moment. What happens, as the court knows, with periodic garnishments, and everything I'm saying is all crystallized in black letter law of MCR 3.101 with periodic garnishments. When the legislature went to continual garnishment with periodic, like this wage garnishment, basically the garnishment statute says the wage garnishment continues until the garnishment is paid in whole. What happened was that also MCR 3.101 requires the plaintiff's attorney to mail, although it doesn't say the time, it was mailed from my office to the employer back in January 2022. The last payment on the periodic garnishment I received this year, like Ms. Robinson says, was in January of 2022, where I received $84.06. Because I showed a remaining judgment balance due statutorily, I sent a letter to the employer saying this is what has been paid, this is the remaining amount due, and then the garnishing defendant resumed the resumed the periodic payments as required by MCR 3.101 with a payment of $178.03 that I received and posted on April 22 of 2022. Therefore, it is true that there was a small interruption because I had to verify under MCR 3.101 with these continual garnishment what the remaining balance was due on the judgment.
Okay. All right. Anything else you want to tell me, Ms. Robinson?
No, that's it. I just not understanding. I just don't get it.
Here's what's happening. Judgments live until they're satisfied or for 10 years. The plaintiff can garnish during that time. Garnishments used to expire. Wage garnishments used to expire after a period of time. The legislature, or should I say the court, changed the law in that regard. Now, the garnishment stays alive until the full amount of the judgment, interest, costs, attorney fees, etc., has been paid. However, every year, it is now the obligation of the plaintiff, that is the person who is garnishing, to send an updated balance statement to the employer. She used to owe this amount of money, now she owes that amount of money. And during that time period, they don't do garnishments. So you're close to the end of the resolution, but at this point, it appears that the judgment in full, because you're paying 13% on it, has not been satisfied. The court's going to find you failed to state a valid objection to garnishment. You, of course, have an absolute right to appeal my decision. That appeal must be perfected within 21 days today in the Wayne County Circuit Court. Ma'am?
So I'll never get finished paying this off.
That's not what I said. That was not what I said, ma'am. What I said was the garnishment remained in effect until it was satisfied. I did not say you would not never pay it off. That's not what I said, ma'am. Okay, I'll send you guys out an order. Thank you.
Thank you, Judge.
We're off the record. Mr. Rules, I believe you have another file.
I have one last matter on your docket.
They don't understand.
I can tell you, Judge, that parenthetically, it was a lobbyist from the Michigan Chamber of Commerce that put through that continual garnishment with a Western Michigan House representative that I knew there was going to be problems like this, but I'm not on that committee.
All right, let's finish my last objection garnishment with you today, sir.
Yes, Judge, that's the last one.
Calling case number 21-164-461, Credit Corp Solution versus Lindsay Longmire. This is an adjourned date on the objection to garnishment. We were last together on this matter on April the 20th. The defendant claimed that the funds that were at issue were exempt. This matter is scheduled for hearing today at 10 o'clock. It's now after 10:40. Your appearance, sir.
Judge, may I please court, my name is Attorney Richard Gruson, my bar number 35222. I'm the attorney of record for the plaintiff. I am the respondent today on this adjourned hearing. And I note with interest that the defendant has not appeared today by Zoom, even though she was advised at the previous hearing of the date and time and place. And so I would ask that because the defendant is not here today to prosecute her objection, that the court deny.
Just so the record is clear, when the court adjourned this matter, I adjourned it to a date and time on the record and sent to both parties written notice of that adjournment. So she not only got verbal notice at the time of the hearing on April 20th, the court sent a written notice adjourning the matter to today's date, May 18th, 2022 at 10 o'clock, and further providing on that written notice of adjournment, defendant to provide written proof funds were exempt. Looking at my register of action, nothing has been provided. Defendant has failed to appear. The objection to garnishment will therefore be denied. We'll send you out an order, sir. Thank you for coming in. We are off the record.
Thank you, Judge. Bye.
Let's be safe.
1930. Successful violin concerto. We just heard the National Symphony Orchestra. Rustic wedding symphony. Hillary Hahn's recent release entitled Paris brings us the city's creative spirit and the passion for education.
I always get goosebumps when I play this piece, usually not when I play. It's usually when I stop in the orchestra. I'm like, whoa, what am I in the middle of? This is cool.
It's great music. Stay tuned to the free WRCJ app and tell your smart speaker to play WRCJ. Enter Warfare with midday music until 3 o'clock today with Dr. Dave. Here's the music of John T. Hall bringing together the Wind Pipes, the great American Main Street band, in the tune he calls the Winds. John T. Hall's the composer. Wedding of the Wind. Brought all together in that performance. Wedding to the reality of 21. Wedding March. He wrote it for his mom and dad. What if before the BCBA competition celebrating their silver anniversary?
Mr. Houlihan, good morning.
Morning, Your Honor.
How
How are you today?
I'm great. I'm really great. How about yourself?
Fine. It's a little bit nicer out yesterday, but it's still not snowing, so we're good.
Hey, we're inside warm and dry. What else you want? What do you have with me today?
We have a continuation of a conference before Mr. Plaintiff's counsel had to provide some information regarding the amount of his claim. You wanted to make sure it was still within your jurisdictional limitations. He wasn't.
What
sure
file
about
is this?
Pardon me?
What's the name? What's the last 3 digits of your case?
I apologize. You want the case number? 177692.
692. I think I have Ms. Clarity here right now. So we can get you started, okay?
Sounds good, Your Honor.
692. 692.
Mary Lou Owens.
Yep.
Your
Oh,
Honor,
good.
Yes.
excuse me, Your Honor, can you give me a call in the courtroom for 2 seconds?
Okay, give me just a second, guys, would you?
Thank you.
Your Honor.
Thank you, Judge.
Glad you got out of that other matter, Connor.
I know by the skin of my teeth, but yeah, I didn't think it was gonna go that long, but you know.
No, you did the right thing. Giving us notice, so.
Yeah, absolutely. Oh, did you go to that Hope Volunteer Day thing, Jim?
No, I didn't make that.
I wanted to go too, but was helping my dad put in docks up north. It was like, you know, I mean, they always have events, but you know,
I've got to get back on the mailing day. On the email address. I'm missing things, so.
oh, he had I have an email here if you want it. Or I can email it to you if you want.
Yeah, do that later. We'll talk later on anyways, okay?
Okay, that sounds good.
Appreciate that. Thanks.
All right, gentlemen, sorry about the interruption. Let's call your case. This is Mary Lou Owens versus Auto Owners, 22-177-692. Your appearances.
Good morning, Your Honor. Connor Clarity, P84485, appearing on behalf of the plaintiff.
Morning, Your Honor. James Houlihan, P40623, on behalf of defendant.
Okay, the big question here is whether or not you're in the right place. Is this a circuit court or a district court case?
It is a district court case, Your Honor. I did my homework this time. I've got an exact number for the court and what's as to what's in controversy. Total outstanding PIP claim is $21,431.95.
No ongoing.
Well, there is an ongoing wage loss claim. However, my client has applied for Social Security disability. Whether or not she is granted Social Security disability still up in the air. She is over the age of 50, so it's a strong possibility that she will be. So we're kind of in this limbo, but I know when we last spoke, Your Honor, you wanted me to get an exact number.
Yeah, because again, if it's not going to be in my jurisdiction, there's no point in me spending more time on the file. And it sounds like what's your client's wage? If she got an ongoing wage claim, you have less than $4,000 less in my ceiling. That's See,
Not a lot of
like
wiggle
a
room.
beer.
You're right, Your Honor. Yeah, so her hourly is 12 an hour. So by the time we get over the assuming that Social Security disability isn't granted, it would probably be another 4 months. She'd be over the jurisdictional limit.
And when did you apply for Social Security income disability?
She applied, I believe in September of 21, but she didn't hear anything back from the Social Security Administration. So she doesn't, and I asked her if she's had it. Well, I can't really get into that because it's,
Yeah, I understand.
communications, but with that said, she hasn't received any money from Social Security. So that's
All right.
why this is going, this is
All
why
right,
it's going on.
this is what I'm going to do. I'm going to give you guys another date. And when we're together again, I'm going to still want some more information on this because it sounds to me like we're perilously close to my subject matter max jurisdiction.
Well, Your Honor, if I may, Jim, do you just want to step to move this to circuit?
If that's what you want to do.
Because I know,
we have some initial discovery, Your Honor, and if it appears that he's going to be over there, that's fine.
I gave you guys an order for discovery. I signed it on May the 13th.
We have exchanged discovery, and I did get some communication from him this morning. I do not have the St. Mary's Livonia records, which are pretty, that's the brunt of the medicals. I did not receive those yet. And we talked about taking the deposition of his client, and I'm not sure what the court's position is on that.
Well, you can do anything you want by stipulation.
Okay, thank you.
I'm going to give you guys a return date of June 15th at 11 o'clock. Does that work for both of you?
It will work, Your Honor.
Okay, then we'll continue our pretrial to that date, June 15th at 11 o'clock. And let's be mindful of my subject matter jurisdiction, Max, gentlemen.
yes, Your Honor. Thank you, sir.
We'll clarify that, Your Honor. Thank
All
you.
right.
Have a
June
good
15th,
holiday.
Okay, you too. Let's be safe.
Yep, thanks.
Bye-bye.
Thank you, Jim.
turn off the sheet. It's not. Well, you feel comfortable. Let's skip that one, man. Mr. Weberman, good morning.
Good morning.
What file do you have today?
I have HS Financial.
Lorraine Barker?
Barker, yes, correct.
Okay, were you able to make, this is scheduled as a creditor's exam. Did you make service?
We did, Your Honor. I'm
Okay,
just trying
because
to
it's not in
pull
my
it up.
file. That's the only one you have?
I believe that's the only one I have, yes.
Okay, let's see. You did make service.
Yep, served Friday, April 1st.
That's 10 days. Okay, I'll get back to you.
All right, thank you.
Mr. Lynch, good morning.
Morning, Judge. How are you been?
I'm okay. How about yourself?
Pretty good.
You've got Sherwin-Williams project versus Martez Speed Diamond project. Were you able to make service?
No, sir, I was not.
Okay, then let's call your case and I can dismiss your subpoena. We'll get you on your way. 9/26. 9/26. We are on the record calling file number 20159-157-926 Sherwin-Williams versus Diamond Project LLC and Martez Speed. This is the date and time, hopefully, for a creditor's examination. Court signed a subpoena that appeared on or about April 2nd, 2022 for today. Could I have your appearance?
Morning, Your Honor. Stephen Lynch, P70211. I'm the attorney of record for Sherwin-Williams Company.
And Mr. Lynch, were you able to serve Mr. Speed, the person for whom we wanted to have our debtors exam?
No, Your Honor, I was not able
Did
to.
not do that. Okay. And my subpoena was dated 4/2/22. The court's going to order that quashed and we'll try again another day.
Thank you, Judge.
Thank you, sir.
Have a good day.
You too, sir. right back. Let me tell these people they're gonna be last. 'Cause I have to think about start video. Admit. Admit. Hello.
Hello,
All right, I'm waiting for, hello, Miss, waiting for her to catch up.
Miss. This is Miss Bell.
Okay, Ms. White, I have both of you on the line. I am here today for your bench trial, and I want you to know I haven't forgotten about you. We will have your bench trial, but because this is a small claims appeal and it's done off the record, I have to finish my first docket first. So I'll be getting back to you in about 10 or 15 minutes.
Okay,
Put you back in the waiting room.
all right.
Yeah. Welcome to my world.
He disqualified Judge Davis.
I saw that.
So I'm trying to kind of do what I can.
Well, there's nothing to the problem with this. Now it's gonna be a question of whether or not anybody, because
I don't know if there's an appellate process for her because it says that there was some financial reporting issues. I don't know if there's an appellate process or a referendum.
no, I don't think so. We are on the record calling 20149-897 HS Financial versus Lorraine Barker. This matter by,
Morning.
good morning, your appearance, sir.
No, Daniel Weberman, P76609 on behalf of the plaintiff.
Mr. Weberman, on March 16th, the court issued a subpoena compelling the defendant Lorraine Barker to appear today at 11 o'clock by Zoom for a debtor's examination. Were you able to serve that subpoena?
Yes, Your Honor. The defendant was personally served on April 1st.
Okay, that's going to be obviously more than 10 days prior to today being May the 18th. She has failed to appear. So what I look forward to, sir, is your the proof of that the subpoena being served and your motion for an order to show cause.
Yes, Your Honor. I'll have that sent in promptly.
Thank you.
Thank you. Have a good day.
You too, sir. We are on the record calling file number 211603555, College for Creative Studies versus Carl Chuney. I have a letter here from the counsel for the Velo Law Office indicating that they were not able to serve the defendant. Although they requested a 90-day extension, the court is going to decline to extend the subpoena for 90 days. I will in fact quash the subpoena and they'll have to proceed another venue or file another subpoena. Okay, that's going to conclude the morning docket. Stop the video. Turn on this music.